Hello. Hello, do you hear me? I can't hear you.
Hello, good day.
Yes, good day.
Nice to have you on the program. I'm just trying to do some last minute. Just give me a few seconds. Juliana Imam is not able to be here today, so I'm standing in for her on the mentorship session today.
Okay, I know. She wrote me. She gave the bus.
Okay, we're very glad to have you. I'm just trying to get some information up very quickly. It won't take a second.
Okay.
Yes, I'm good to go. Nice to meet you, Maria Koval.
Thank you. Nice to meet you too.
Yeah, my name is Joseph. Joseph Oboh is my name,
Yes.
and I've read through your resume. I've read through. I'm very impressed that we're having you today, and I'm very sure that your intervention would be of very great value and benefit to our mentees in today's session. It's my pleasure to read through your resume very quickly so that our guests know who we're actually speaking with. If you don't mind, I'll do that very quickly within the next couple of minutes.
Okay.
Yeah. So to our guests out there, today our topic is domain name arbitration with the World Intellectual Property Organization, WIPO, Arbitration and Mediation Center. And our guest, our mentee for today is Maria Koval. Maria Koval is a counsel and head of intellectual property practice of Redcliffe Partners. Maria is a domain name arbitrator of the World Intellectual Property Organization Arbitration and Mediation Center. She specializes in all intellectual property issues, including trademarks, designs, inventions, domain names, copyright, trade secrets, data, and data protection matters. Maria has a long track record of advising multinational and Ukrainian companies on the various IP issues, such as possible rights infringements, strategies on IP rights protection, licensing and franchise agreements. Maria regularly handles litigation on various intellectual property issues. Before joining Redcliffe Partners, Maria practiced intellectual property law for more than 12 years, over a decade, with Krylova and Partners in Ukraine, and for more than 3 years with Ilashev and Partners law firm. I hope I pronounced that correctly.
Everything is correct. Thanks.
Yeah, thank you. Maria is recognized as an up and coming IP lawyer by Chambers Europe 2020 and recommended for intellectual property law and media law by Best Lawyers 2021. In Ukraine, Maria is also ranked amongst practice leaders in IP by Client Choice, Top 100 Best Lawyers of Ukraine 2019. We're very happy, we're proud, and above all, we are very humbled to have you on the mentorship session today. I believe that Nigerian mentees would definitely be getting a whole lot of the international exposure that you will be bringing to the mentorship session today. Once more, we are proud to associate with you and we're happy to have you on today's session. So you're very welcome.
Thank you. My pleasure also. So I can start. Yeah.
Definitely. Yes, you can.
Thank you very much for a brilliant presentation of my professional activity. I'm Maria Koval. I have an experience in intellectual property for almost 20 years already. I'm also an international arbitrator of the World Intellectual Property Organization in Geneva. I resolve more than 50 domain name disputes already. I will tell today about alternative dispute resolution regarding domain names. So I will share my presentation for the best. So we will talk today about internet domain names and the uniform dispute resolution procedures. What is it in general, domain name? According to the indications in different legislation, domain name is the address where internet users can access the proper website. It's a common indication that everybody knows. Domain is a name used for addressing computers and resources in the internet, and domain is its more technical indication. Domain is part of hierarchical internet address space. Of course, we know that the domain names are not the type of intellectual property objects. However, it is a very specific mark for indication, of course, for presentation, the goods and services of any producer and manufacturer. So domain names is rather strong indicators of goods and services. And of course, so we have many problems with illegal domain names registrations in the world, I mean, which is called cyber squatting. If you have any questions, you can ask me during the presentation and during my speech, or in the end of my speech, wherever you want. What is it, cyber squatting? Cyber squatting is a process of registering, trafficking in or using an internet domain name with bad faith intent to profit from the goodwill of owner trademark belonging to someone else. It's rather common problem in the world now. Of course, the WIPO in Geneva cannot be out of the sight of this. We all understand that this problem must be resolved, and in any jurisdiction, I mean, all over the world. And of course, that not all owners of trademarks or domain names can go to the court and have the legal proceedings. In view of this, legal proceedings are rather expensive. Cyber squatting refers to illegal domain name registration or use. It's a special term for illegal registration of domain names. Primary purpose of cyber squatting is to steal or misspell a domain name in order to profit from an increase in website visits, which otherwise would not be possible. So illegal registrants register domain names primary of well-known trademark, of course. They use different ways to change the domain, to change the trademarks in the domain names. I will further show the examples of illegal registration of domain names for your general presentation. So let's go. In 1999, WIPO adopted international procedure on alternative resolution of domain name disputes. Trademark owners from this year has a possibility to resolve obvious disputes in respect of illegally registered and used domain names. So it's a struggle against cyber squatting, and it must to say that it is a very success struggle. It is non-judicial dispute resolution. So what does it mean? It means that the owner, so the complainant, may be from any jurisdiction of the world. We are not talking about any jurisdiction, so it is not the same as a legal proceeding. It is possible to file the complaint directly to the WIPO without any specific and difficult procedures as we have in the court, for example. This procedure applies via mandatory domain name registration conditions. So when any registrant registers a domain name in the world, he agrees, or she, of course, agrees to condition for effect of this dispute domain name resolution procedure at once when when they register the domain name. This procedure applies to all so-called old domain names, common, com, org, net, and etc. There are so many of them, and two new ones, Tony, Club, and etc. The complete list of applied domain names, com, org, and net, is on the website of the WIPO. Also, this procedure applies to 75 country code top level domain, for example, for Australia, Spain, European Union, even for Ukraine from last year. And there are so many of them, and they are very successful in each country now. What is it about Arbitration Mediation Center of the WIPO? I am the part of this center already 3 years. This center was established in 1994. Now it is a part of WIPO, located in Geneva, and the center has also the department in Singapore for about 10 years already. From the date of the center establishment, the center resolved more than almost 50,000 domain name disputes, which with participation of parties from all over the world. As can you see, it's 177 states, so it's almost a full list of the world countries, and in respect 80,000 domain names. You can see here top 10 plaintiffs' fields of activity. So it's fields of activity. It's domain names where the legal registrants primarily register domain names. So as you can see, there's a primary biotech and pharma, internet and IT. So it's activity of the complainant, the trademark owners, something in electronics, something in food and beverage, retail, fashion, hotels, and travel. So this is the scheme where can you see what fields are popular for cyber squatters. Advantages of domain name dispute resolution by the Arbitration and Mediation Center are obvious. It's very comfortable and very quick proceeding in general. From the moment of complainant's filing to the center and up to obtaining a decision to the legal owner runs no more than 60 days. So the complete procedure takes 60 days without any delays if the documents, of course, which have been filed by the complainant is in order. Internationality, I already said that the complaint can own trademark rights, for example, in France or in any other country. Respondent, for example, may have location all over the world also, so there is no any principle where the respondent is. This will not a barrier for the application to the center. So it means that if the complainant, the trademark owner, for example, has trademark rights for example, in Canada or in Nigeria even, and for example, the respondent took this domain name in Ukraine, so the complaint has the right to file such a complaint to the WIPO, of course, with in order to comply with all conditions of filing of such complaint. Cost. A resolution of a case in respect of from 1 to 5 domain names. I will say further about the total cost of domain names procedure. If it is single panelist, so the most common dispute resolution is by one single panelist, it's $1,500. Resolution by 3 panelists, it depends on the complexity of the case. For example, sometimes we have a very difficult case where the parties file so many documents and the situation is not so clear. It will be resolved by 3 panelists and the cost will be $4,000. Parties' personal presence, including any conference, teleconference, even Zoom or any online platform, is not requested at all. So everything is done in electronic form, filing and communication with the center only by email. It is very convenient that the enforcement of decision is realized directly by the registrar. The registrar, after receiving the copy of decision from the WIPO center, has 10 days for decision execution. It's very convenient. The parties and the complainant should not do anything. It is everything is done by the arbitration center. So in general, this procedure is very comfortable and quick, and it consists not so many costs as, for example, legal proceeding. WIPO mediation centers decisions are all available for review, so you can see all decisions from 1999. They are published on WIPO website. I show the link to it, so you can see any decision regarding any domain name, regarding any jurisdiction, and regarding any panelist. So it's very convenient website, and it's very interesting to read such decision, because decision, not so many decisions are difficult, but most of them are rather interest for understanding the connection between trademarks and domain names in general. Filing of complaint to the WIPO. Complaint and response to the complaint by the respondent are filed to the arbitration center online and in certain form. The WIPO has the shape, the type, model complaint and response to the complaint, so it cannot be filed, for example, in ordinary form, or if a party wants to file it by themselves. The WIPO has specific forms of this complaint, so they are also all on the website WIPO. It's very convenient website for use. Right for filing a complaint has any person or organization who considers that their trademark rights have been violated. Complaint may concern few domain names upon conditions that domain names are registered by the same registrant. It is a rather popular situation, rather common situation, when one registrant registers, for example, 10 or 20 domain names. Corresponding with the center, as I already said, only in electronic form. Filing an opposition against the complaint by the respondents is 20 calendar days from the date of beginning of the administration proceeding. Language of proceeding. In general, the language of proceeding is the same as the language of the relevant registration agreement. So when the registrant registers a domain name, they sign in electronic form, of course, they sign registration agreement, and according to the WIPO rules, the language of proceeding regarding domain names dispute resolution must be the same language as in the registration agreement. However, often we have the situations where the, for example, registration agreement is in Russian or is in Chinese, but the complaint asks and files a special form form of petition that, for example, he wants that the dispute domain name dispute resolution be in English, not in Russian and Chinese. So we are, as a panelist, in each case considers whether there are any conditions for consideration the case in English as the complaint asks or not. So it depends on circumstances and it depends on each case. The complainant, as I already said, has a typical form on the WIPO website. The complaint should include some specific information. It's obligatory and mandatory requirements from the WIPO. So if some of this criteria be absent in the complaint, the WIPO will refuse in filing the complaint. So it should be noted that any of these clauses should be included in the complaint. For example, we all understand that there are the contacts of the parties and so on, and the most, how to say, the main requirements of the complaint. I will say about it also further. First of all, the complainant should confirm that the domain name is identical or confusingly similar to his trademark or service mark. The second is that the respondent should be considered as having no rights or legitimate interest in respect of disputed domain names. And the third one is why the domain name should be considered as having been registered and being used in bad faith. So there are three main elements on which the each complaint is grounded. It's I would say it's the base for any domain name dispute resolution with the WIPO. So it should be noted that before the filing the complaint, if complainant trademark owners understand that he could not prove even one of these elements, the complaint should not be filed because it will not be succeed at all. Who are WIPO domain panelists? The persons, so it's me also. We have in the list 400 panelists from over 50 countries, many of whom are multilingual. For example, I write the decisions in Russian, in Ukrainian, and in English. The list of panelists are available also on the WIPO website. Who decide which panelist will be resolved the case? It's always WIPO Center, so the Arbitration Mediation Center in each case decide who will be the panelist. The parties cannot choose any panelist if we are talking about single panelist. Case if it will be three panelists, for example, when the case is very difficult or complicated, the parties, the complainant and respondent, has the right to choose each panelist from their side. So I also participated in the panel with three panelists, and for example, the complaint asks that panelist, for example, me, Maria Koval, will be the panelist from his side. So there are three panelists, and in this case, only in this case, when participation of three panelists, the parties can choose of one panelist. Panelists, of course, shall be impartial and independent. We understand that we should check conflict of interest in each case, whether they are not our client, whether they are not they were not our respondent, and the connection with any of our clients. So it's a rather responsible case, and we sign the declaration for each case. For example, like a judge. As I already said, there are compulsory elements for proving in the administrative proceeding. So it is the base for filing of any domain name dispute. The trademark owner should file all documents that he has a right the inappropriate trademark. Of course, the disputed domain name should be identical or confusingly similar to his trademark. The respondent does not have any rights or legitimate interest. For example, there are very common situation when the respondent, for example, registered trademarks prior to complainant, even prior, or coincidentally with the complaint. So there are common situations when the respondents can have rights or legitimate interest in respect of disputed domain name in view of, for example, he has trademark rights for this domain name, but for example, in other classes for registration. Of course, the disputed domain names should be registered or is being used in bad faith. So before the filing the complaint, it should be comprehensible that registrant registers the disputed domain name, for example, with the purpose to have some profit or to have a link for his website with use of reputation, goodwill of well-known trademark owner, and so on. So these compulsory elements should be proved before the filing the complaint, and they should be described in the complaint. As soon as the complainant file many documents in proving of these elements, as soon as the proceeding will be in his favor. You can see the examples of registration of confusing with similar domain names. And so all of them are precedents of the WIPO centers. According to the general rule, if the domain name includes a trademark in its entirety, it's how you see, for example, Electrolux product, Electrolux Russia, and so on. The disputed domain name is considered confusing or similar to the trademark. So there are four types of use of the cybersquatter, the illegally the domain names. First of all, they added other terms, for example, descriptive, geographical, meaningless, or otherwise any term to the well-known or to the trademark. You can see Electrolux Russia, for example, is geographical, Electrolux products is descriptive, or our bank it's also descriptive. So it's examples of how a cybersquatter registers the domain name. Domain name consists of misspelling of the complainant trademarks. It's so-called typo squatting. It's rather a common situation for registration. So the internet users, for example, when they enter the website Electra or Lux, they very often doesn't pay any attention that there is no original website. The third domain name consists of the complainant's mark plus a third-party trademark, for example, Yahoo, eBay, Palmo, Marlboro. So it's also a rather common situation when, for example, they are the distributes or so on. And domain names consist or comprise of translation or transliteration. So it's examples of how the cybersquatters register the domain name with use of well-known or trademarks in general. Evidence of respondents' lack of rights or legitimate interest. So we all understand that it is very complicated it's very complicated to prove by the complainant that the respondent does not have any rights or legitimate interests. First of all, the complainant should understand that before any notice of the dispute, so before the commencement of proceeding, the respondent's use or demonstrable preparation to use in connection with the bona fide offering of goods and services was not realized. So sometimes in some cases, the respondents argued that they made demonstrable preparation for use. They prepared and they are going to use this domain name. So the panelists should consider in each case whether there are any grounds for understanding whether the respondent made real preparation to use or whether it is false. The second, the respondent has been commonly known by the domain name. So if, for example, respondent registered the trademark or domain name prior to the complainant. He or it may be also a company. It may be commonly known in his jurisdiction. And sometimes we have such cases when we should refuse the complainant in satisfaction of the complaint in general, because the respondent is really commonly known by the domain name, so it was prior before the complaint. And the third one, the respondent is making a legitimate, non-commercial or fair use of the domain name. Of course, more often than the respondent uses disputed domain names for traffic to his website, or to malware computers, or for any profit, for redirecting to the competitive website. And of course, there is so common situation. So the panelists should understand whether the respondent making a legitimate, non-commercial, fair use. For example, it may be a website for criticize of any actions of a complaint, so it will exclude the responsibility of the respondent. So there are many situations where the respondent can have rights or legitimate interest in a domain name. Bad faith. What is it, bad faith? So when we consider the cases, we should understand whether the domain name were registered or being used in bad faith. For example, the respondent may register or acquire the domain name by primarily for the purpose of selling, renting, or otherwise transferring the domain name to the complainant. For example, we have such situation when before the commencement of the dispute resolution proceeding, the complainant sent the cease and desist letter to the respondent, and respondent responds him that, okay, I agree to transfer to your domain name, but for example, for $10,000. Of course, it indicates a bad faith because it is comprehensible that the respondent registered the domain name primarily for selling it to the complainant. The second one, the respondent has registered in order to prevent the owner of the trademark from reflecting the mark in a corresponding domain name. For example, when the respondent registers domain name with many .com, .org, .net, and so on, so they close the entrance to the market, to some market for the complainant. The third, respondent has registered the domain name primarily for the purpose of disrupting business of a competitor. So, for example, we are talking about the situation when the disputed domain name redirects to competitive website. And the fourth one, by using the domain name, the respondent has intentionally attempted to attract for commercial gain internet users to his website or other online location. Of course, all these elements, all these criteria depends from one case to another. So we have many situations when the respondents try to keep his domain, and he files many documents, many oppositions and arguments that they have registered the disputed domain name in good faith and so on. But it depends from each case. Cost of domain name dispute resolution by the center are the following. If we are talking about consideration of the case by one panelist, it will be $1,500 or $2,000. It's this cost divides between the WIPO center and the panelist. If we are talking about more than 10 domain names, it is always agrees with the center, but it will be no higher than $5,000. If you are talking about dispute resolution by 3 panelists, the costs are higher. From 1 to 5 domain names, it's $4,000. From 6 to 10, it's $5,000, and more than 10, again, as agreed with the center. So the most high is the $10,000 for example, even for 100 domain names. Remedies under UDRP. The remedies, there are only two remedies available to a complainant person to any proceeding before an administrative penal. The complainant can ask either to cancel a domain name or to transfer a domain name registration to the complainant. Of course, the most common situation when the complainant asks to transfer the domain name to him, because if it will be cancellation domain name in 10 days, any person could register this domain name again. So it's better to ask to transfer domain name registration to the complaint. Also, the panelists, we can refuse the complainant at all. So we can not decide the case, but we can refuse because, for example, there are no grounds for satisfaction of the case. So we understand that this dispute between the parties should be resolved by the court, because sometimes there are many complicated situations. Relationship between the owner of the trademark and the respondent. So it's not that always the case will be decided in the favor of complainant. Also, it should be noted that the center does not resolve the matter of compensation for damage and the legal cost. So it's alternative dispute resolution. The center decided only all matters regarding the domain names. Any compensation for damage and the legal costs should be decided by the court in that jurisdiction in which the complainant lives, and or in the jurisdiction where the respondent is. So it should be noted that alternative dispute resolution never resolve any matters for compensation, so no costs for damages or legal costs. Examples of decided domain names disputes, it's for your consideration. The first case was mine, sellwikipedia.org. In this case, it was very interesting case because there were so many documents were filed by the complainants and respondents. Respondent argued that they have sellwikipedia.org in good faith, and they have this website for educational purposes, and they ask not to transfer. But of course, all rights were on the Wikimedia, so Wikipedia site. So I decided to transfer the disputed domain name to the complaint because the respondent did not have any rights, of course, in this trademark. But you can see here how its dispute domain names were used by the registrant. The second case, Telegram group, WhatsApp group com. So it's one trademark plus another trademark. So it's rather popular situation also for registration. In this decision, the complainant asked to cancel the disputed domain name. For the purpose, it's obvious that the WhatsApp, for example, doesn't want to have such a domain name. It doesn't need it because Telegram, it is registered to trademark by another person. And the third case, it's KPMG group. So you can see it's it is used KPMG and group. So the complainant asked to transfer the disputed domain name to the complainant. And in general, I would recommend you to go to the WIPO website and to read these decisions, because I started to read these decisions almost 18 years ago, and I was fond of this domain name dispute resolution and never thought that I could be an arbitrator. So it was like a dream, but it's very interesting decisions because they can give you imagination about connection between domain names and also with all objects of intellectual property. The documentation is rather good, so it will be, I think, very useful for you and very helpful for understanding how the domain name and trademarks are connected in general. So which are the rights of complainant and respondent should be in each case. So let's go and see, because the WIPO has a very convenient website in general, even for international registration procedure. So it's very useful for you if you're going to connect your life with intellectual property. So thank you very much for your attention. If you have any questions or will have any questions, I would be glad to answer to each.
Thank you so much, Maria. Thank you. This is one of the most informed lectures that I've had on the issue of cybersecurity.
I will send you a presentation.
Thank you so much. Thank you so much. The mentees, I'm sure you can see the message board. They're saying thank you. But I'd like to encourage our mentees right now. If you have any questions, Maria is here for you now. She will be taking all of your questions.
Yes, I can.
I know that there's no question too difficult for you to answer today. Well,
I think that it's difficult to ask the questions, because you see, if you are in this proceeding, yes, you understand what you want to ask. But in this, I understand that this general information are rather complicated to understand it. So it's
yeah. Thank you. Let me go first. The aspect that has to do with the fact that the arbitration committee does not deal with issues for damages or legal costs. You made that known during the presentation. So I wanted to find out, can the committee advise? Can they give advice to the parties who want to move from the arbitration committee to maybe going to court to go and seek damages and all that? Do you give advisory to the parties in that respect?
You mean the center, no committee? Yes, the center, arbitration center. The WIPO in general never advise any to the parties. And of course, I, like a panelist, I have no connection with the parties because I'm independent. I have no right to advise. But if it concerns, for example, with my client, I can also file a complaint, but I cannot be a panelist in this case, of course. I can advise, of course. There are so many informations on the WIPO website. There is Q&A link where it is possible to understand the procedure and where all the parties should go. But in general rules, they should go to the court in the proper jurisdiction.
Okay.
So
the reason I actually asked this question is because I know that not every country has very developed court systems that are specialized in this area of intellectual property that deals with domain names, cyber squatting. If for example, an individual might not be able to get justice within their country, in that sense, are there other channels that are available for them, especially when they are seeking compensation?
Probably I didn't understand exactly for your question. What do you mean?
What I mean basically is where certain countries lack the intellectual, where the court systems in certain countries may not necessarily appreciate intellectual property or the issues of maybe cyber squatting and these domain issues that you've mentioned. Beyond the court's available system, are there any other means through which individuals can actually seek damages?
They can seek damages, but you see, it depends. If you're talking about the so-called old domains, .com, it's very important to understand who is the registrar. So in which jurisdiction this domain name was registered. It's very complicated often to find out where the damages can be sought. So if we are talking about, for example, country code, yes, UA, for example, UA, it's comprehensive as we can seek the damages in Ukraine. But sometimes, of course, the parties, the complainant should decide whether he is ready to go, for example, to American court if the registrar is an American company. In which jurisdiction the domain name was registered? It's the key question for seeking the damages. As I can see from the experience of the WIPO domain name resolutions in general, almost 3%, I think, sought the damages at all. Wow. So the purpose is to cancel domain or to transfer, to return it, not for damages, because it's rather complicated procedure.
Okay. I think that's extremely clear. I want to see if we have some questions.
Yes, I see. Is it a must for a complainant to be represented by a lawyer in such cases? No, it is not obligatory requirement. Of course, it's better when the complainant is represented by a lawyer, because the procedure has some specific criteria and some specific requirements. And for avoiding any delays with the complainant, and for avoiding the case when the complainant should be refused, of course, it's better to be represented by a lawyer, but it's not obligatory. Any complainant can file a complaint directly to the WIPO by himself.
Okay. That makes a whole lot of sense. It also improves the access that individuals actually have, which is a very good one. And I also think that it's not expensive. It's not expensive. It's accessible. It's affordable, and it's very useful for a lot of businesses, because I have personally, based on my own personal experience, I've seen several cases of domain similarities with a view to even to deceive the public. I've had a personal case at our firm where an individual who gave access to his domain or his profile to a friend. The friend registered a domain, the same, very similar domain, just added two extra words. So I don't think they are actually aware of this particular initiative for them to be able to at least get the input of the committee. And at least flowing from this conversation, I'll do very well to let them know of the presentation you've made, so they can also proceed to find more support within what the committee actually is offering. Do we have more questions, please? Do we have more questions? Mr. Daniel of Funre, Longe, Christiana, do we have questions so that we can actually take the questions? I wrote something else down. I wanted you to throw more light on the issue of non-judicial dispute resolution. I didn't quite get that part of the presentation.
You want the title about?
I need you to explain. I need you to explain that. Okay. Sorry. I think what I wanted to say is in terms of, okay, I think most of the questions I have, you have actually already answered them. I wrote them at the earlier part of the presentation, but as you went on with the presentation, you began to touch on some of those areas. I'm still trying to see if we still have certain other questions. I was actually, okay, we have one. We have another one.
The most common remedy given to a complaint is the transfer of the domain name. So as I already said, there are only two remedies possible in this proceeding. They are either to transfer the domain name to the complainant, either to cancel. All these decisions, either to transfer or either to cancel, is executed by the registrar. So the registrar decided to transfer. He changes only the owner of the disputed domain name in this case, or to cancel. So this domain name in this case will be free for registration by any purpose. So the most common, of course, it's transfer. Will it be a defense to claim ignorance of the similar domain name? You mean that if the respondent does not file any response? Yes, as I understand. Will it be a defense to claim ignorance? Yes, it's correct, my understanding. To claim ignorance of the similar domain name. If you mean that the respondent doesn't file any response and doesn't participate at all in the proceeding, it will be not considered as a defense. It will be considered by the panelist as a non-participation of the respondent. So it will be the case resolved, of course, in the favor of complainant. If we are talking about similar domain name, for example, the domain name may differ from trademarks by some letters, by some words or so on. It's also not defense because the domain name will be considered as confusing or similar. So it will not be the case. There are no any expertise by, for example, examiners in this case. So the panelist decides the case only by himself. We consider that we have such experience and we can decide whether it's a similar domain name or no. Of course, we take into consideration any responses of the respondent and any materials filed by him. But in general, the respondent should defend, of course, should file possible documents and should participate in the proceeding, because otherwise he will lose the case. So I hope that I respond to this question.
Yeah, I think you've done so much justice to this already. I think, okay, I thought somebody dropped another question. If we don't have any other question, I was okay. You've already. Sorry, I wrote some things down. You've already dwelt with the remedies available. There are just two of them. It's either to pull it down or to transfer the domain. It doesn't go beyond that. There is no other available remedy. It's just those two remedies available.
Two remedies, transfer and cancel.
Oh, okay.
Must a contract include the WIPO idea for the parties to have access? No contract between WIPO for the parties to have access if we are talking about domain name resolution, dispute resolution. If we are talking, there are another part of the arbitration and mediation center. If we are talking about intellectual property disputes, it has no concerning to the domain name. Regarding domain name, no non-contract should be between the parties or between the WIPO or IDEO. It just should file the complainant. If you're talking about alternative dispute resolution by the WIPO in general, for example, it may be the patent disputes or something like that, or even copyright disputes. Yes, the parties, there are four types. It's arbitration, mediation, and joint mediation by the WIPO. If the parties, for example, complainant and respondent, decide that they want to, for example, use the WIPO as a mediation center, yes, they should sign the contracts in this case. But I again say it is no concern into the domain name dispute resolution. In domain name dispute resolution, there are the same analogy like in court. The complaint files the complaint, and the respondent should defend. So it's no contract possible.
Okay. I also wanted to know if for example, following the use of a domain that has breached the code of ethics and now falls under cyber squatting. If somebody has used that domain, for example, to defraud maybe unsuspecting members of the public by virtue of using that particular domain for any transactions, for example, does the committee entertain, arguments within that direction?
Any arguments of the respondent in each case, it doesn't depends on which activities the respondent has. For example, the respondent has used or is using domain name for, as you said, transaction of any information. If I exactly understood you correctly, if the respondent uses the domain name in good faith, so for example, he uses this domain case for his activity at all and has no intention to disrupt the complainant's business. Yes, of course, the WIPO center takes it into consideration, but of course it depends from each case, on each case. Can two parties from same country seek redress at WIPO? Yes, of course they can. You should understand that if we are talking about the common domain name .com.org, yes, there are many possibilities to participate in this proceeding. Of course, two parties from the same country may seek a redress. If you're talking about country name, for example, it's .ua for Ukraine. Yes, the complainant and respondent can be from Ukraine, of course, but you should understand that not all country code are available for dispute domain name resolution. Only that countries that signed the special contract with the WIPO Center. For example, Ukraine signed this contract 1 year ago, and so we have the disputes for .ua and .com.ua. Yes, the two parties from the same country may participate in the proceeding. It is not the problem. Who choose the arbitrator? I already said in my presentation that if this case is resolved by a single panelist, always the center, arbitration and mediation center of the WIPO, decides who will be the arbitrator. If the case is decided by 3 panelists, in this situation, the complainant and respondent has the right to choose 1 panelist from his side. For example, we had 3 panelists, and I was chosen by the complainant. They go to the WIPO website and they can see our biography, our experience, and they can choose us for participation in this proceeding from their side. The presiding judge panelist will be also appointed by the center. So in the most cases, the most cases are decided by a single panelist. So the most cases are chosen by the WIPO, the arbitrator.
Okay. I was trying to put a question down. Peradventure, the parties have already submitted to the WIPO Arbitration and Mediation Center, and the matter is still being heard. Along the line, can they opt for an external settlement and pull out, or must they see the case? Must they see the case to a conclusion?
Don't understand. What do you mean? I'm sorry.
Okay, if for example, two parties before the committee, for example, can they opt out and decide that they don't want to use the WIPO medium anymore? They want to resolve their differences,
By
through other.
themselves, you mean? By themselves, they want to sign a settlement agreement. Yes, you mean?
Yes, yes, yes.
Yes, this situation is possible when the parties declare that but two parties, not only one. When two parties decide that they want, for example, to sign settlement agreement and to cease the administrative proceeding before the center, they can file the special petition to the center if the case is already decided by the panelist, we mean. They should file the special petition that they will sign the settlement agreement with a copy of this settlement agreement. So of course the proceeding will be ceased because the panelist cannot be against the parties.
Yeah.
So yes, of course it's possible, and it's a common situation also in our cases.
Thank you so much. I was expecting to see a whole lot of questions because this issue, this domain issue is it's very popular amongst a lot of businesses. Basically, I personally have had a lot of about two scenarios where domain similarity issues, or maybe one person is having two parties are about to enter into a transaction, and for some reason it doesn't pull through. Then they already have a domain name. The other person can maybe just add a few words and try to turn things around. So I know that it's commonplace to have this within the startup community, basically. And I'm still expecting that we would have a lot more questions, so that before we round it up today, so we can have more questions from our mentees.
I think that if you have no experience with the filing of or with the client's problem with the domain name, it's very difficult to have any question regarding this. And because when you have such request from the client, you understand that you, for example, you know less. And you cannot understand how the procedure works, but of course there are so many specifics, and also we, the panelists, also sometimes have some difficulties with understanding what's going on and what we should do. So there are very common topic and very popular topic. Of course, now it's in the world there is a problem with cyber squatting, and of course many specifications, and even the WIPO issued the special edition. It's a such book with explanation of for each questions. Besides, they also have it on their website, on the WIPO website. So the situation are different and often complicated. But the questions were so interesting, even from the mentees who never, as I understand, participated in this proceeding. So it's okay. Don't worry.
Thank you so much. It's actually I would say it's I don't want to call it it's not a new area, but information around some of these mechanisms that individuals can actually have access to. It's developing within Nigeria. Basically, it's a developing area in Nigeria. But I wanted to know, have you had to in country specific terms, which countries would you say assess the center in terms of percentages in the highs and the lows?
If we are talking about complainants, they are, of course,
Yes.
USA. So the complainants are primarily from USA, from Switzerland, because they have many manufacturers. It's France, Canada, of course. So there are the 10 I think the top 10 complainants are from top 10 most developed countries. But the first, of course, it's USA, because there are so many manufacturers, and for example, Facebook, Marlboro, cyber squatted very often. So the most of them are these companies.
Okay, thank you so very much, Maria. Finally, I just want to know, just out of curiosity, have you had complainants from Nigeria in particular? Have you had any Nigerian complainants?
I have never, you see, I have never met this, yes, but it doesn't mean that they don't exist.
Okay.
Probably yes. We should, for example, I should seek it.
Okay.
I think that it's possible, of course. I will write you later if I found something.
All right. Thank you so very much. It's been a very wonderful session today. I'm very sure we've been able to have this also documented, so that people who could not join us up today on the mentorship session,
I will send you, of course, my presentation. Yes, it's no problem.
That would be extremely helpful and very awesome, and we're very grateful for that as well. I wouldn't know if you have any other words to share before we finally call it a day for today.
I want to thank all participants for participation, of course, and I hope that my speech, my presentation was helpful and useful for you. And I hope that it will be interesting topic for you in general in future, because it's very prospective and it's very interesting in general, as I already said. And I wish you good luck in all your endeavors. And I think that you should do many efforts for understanding the intellectual property object specific. And of course, I hope that all of you will be successful IP lawyers in any sphere as you want. So I wish you good luck, all of you good luck. And I hope that the domain names will be the part of your professional activity in the future. It's very interesting. It's very interesting part of intellectual property, and I'm so happy that I'm the arbitrator. It's many interesting insights for me and for professional intellectual property in general. So good luck, and I hope that it was very interesting for you.
Thank you very much. Thank you so much.
Yes,
definitely. When we have any areas of difficulty, please do not hesitate when we reach out to you for any support of any kind.
Welcome. We also, it's the same. Thank you
Mark.
so much. Yes, and I wish you, yes.
Thank you.
Good evening. Yes.
Have a wonderful weekend.
Yes, goodbye to everyone and good luck.
Bye.
Bye from Ukraine.
Bye from Nigeria. Thank you. To our mentees out there, are there any further intervention areas that we can deal before we call this a day? Daniel, Akinwale, Christina. Juliana wasn't able to be here today, so I had to stand in for her. Hopefully, in the weeks to come, she'll be well able to join us. When that happens, she would let you all know, but until then, I will be anchoring these sessions for her. And I'm also thinking, if anyone, I know she talked about wanting to make the floor open at some point within the year. When that happens, she will definitely get across to all of us. In the absence of any other message, any other concerns, thank you so much. I just hope that Nigeria can really take its place within the trading, of the entire world. Like, to hear that, we don't even have a case that has gone to, I don't think is encouraging. So I hope companies grow big enough to be able to go to the WIPO Center to have their matters dealt with. Thank you very much. Thank you for being around, Daniel. Thanks, Christina. Thanks, Bernice Ofunre. Thanks a lot. Do have a very wonderful weekend, and see you next week right on time, 4:30 p.m. Thank you. Bye.